Prior to the events that occurred in 1988, Article 121, Clause 1 of the Federal Constitution, which deals with the establishment of the superior courts in Malaysia, read in relevant part as follows. The judicial power of the Federation shall be vested in the two high courts, and the high courts shall have such jurisdiction and powers as may be conferred by or under federal law. In 1988, Parliament passed a Constitutional Amendment Act 1988 to, among other things, amend Article 121, Clause 1. The new provision which subsists to this day reads as follows. There shall be two high courts of coordinate jurisdiction and status, and such inferior courts as may be provided by federal law, and the high courts and inferior courts shall have such jurisdiction and powers as may be conferred by or under federal law. This amendment did two things. First, it removed the words, the judicial power of the Federation shall be vested from the body of Article 121, Clause 1. Second, it was worded such that all jurisdiction and powers of the High Court and the inferior courts shall be as may be conferred by or under federal law. Nothing much happened in the many years that followed the amendment, not at least until the decision of the federal court in a case called Kok Wah Kwan. The issue in that case concerned Section 97 of the Child Act 2001. In effect, the provision stipulates that any child convicted of an offence punishable with death shall, instead of being punished with death, be detained at the pleasure of the Yang Pertuan Agong. The provision was challenged on the basis that it violated the doctrine of separation of powers for having removed the judiciary's power to determine the measure of sentence, and with the Yang Pertuan Agong being the head of the executive branch of government, it meant that the measure of the sentence was instead to be determined by a non-judicial body, namely the executive arm of government. Now, what is interesting is that the federal court unanimously held that the provision was constitutional and valid. However, the court was split on its reason. The majority judgment, which was delivered by Justice Abdul Hamid Muhammad, ruled that by the amendment effected in 1988, Parliament had, in effect, removed any vesting of judicial power and emphatically determined that all powers and jurisdiction of the court shall have, as are strictly determined by Parliament. He further reasoned that since there was no express statement of the doctrine of separation of powers in the Federal Constitution, then there can be no argument of its violation in the provision that removes the power of the court to determine the measure of a sentence to a non-judicial body. As you can probably tell, the Federal Court's majority decision was heavily criticized for converting Malaysia into a parliamentary supremacy. It is hard to argue with the critics because the criticism is substantively correct. Reading the amended Article 121, Clause 1 the way the majority in Kok Wah Kwan did, in effect, disregards the foundation of the Constitution in its creation of three distinct arms of government and further treats the Malaysian Parliament like the parliaments of the United Kingdom to the extent that the courts are obliged to uphold any law passed by Parliament as valid because they are subordinate to it. If we apply Kok Wah Kwan's interpretation of the Federal Constitution, then the provision of the Land Acquisition Act 1960 ought to have been upheld as valid. Because if there is no express mention of separation of powers in the Federal Constitution and the courts are bound to Parliament's dictates, then it did not matter that a High Court in any land acquisition compensation hearing was just a rubber stamp for the lay and non-judicial assessors. Clearly, the Federal Court saw the flaw in this and found that it could no longer accept the proposition in Kok Wah Kwan, which now leads me to the bigger picture that was targeted in that case. In Semenya Jaya, the parties challenging the Land Acquisition Act 1960 effectively sought to obliterate the bad precedent that was established in Kok Wah Kwan. For this, they resorted to the Indian Basic Structure Doctrine established in Case of Malaysia for the proposition that there are basic features in the Federal Constitution that cannot be amended even by Parliament, and in the context of Semenya Jaya case, it was argued that judicial power and separation of powers were such basic features. Accordingly, it was suggested that the 1988 amendment was bad in law and the courts were at liberty to strike down the Impugned Land Acquisition Act 1960 provision. The Federal Court in Semenanjaya referred to Article 4, Clause 1 of the Federal Constitution and held that the Indian Basic Structure Doctrine is applicable in Malaysian law. The court then interpreted the amended Article 121, Clause 1, and in my reading of it, held that the majority in Kuat Wah Kuan misconstrued the nature and effect of the amendment. The Federal Court held that while the Basic Structure Doctrine was effectively applicable in Malaysia, there was no need to apply it because, construing Article 121, Clause 1 on a whole, the judicial power of the Federation remains vested in the judiciary, and the judiciary is not subordinate to Parliament in light of Article 4, Clause 1. Semenanjaya then spelled the end of Kuat Wah Kuan and propelled our constitutional law in the right direction. Semenanjaya was followed by two other important constitutional decisions that upheld constitutional supremacy and continued to reinforce the existence of the Basic Structure Doctrine in Malaysia. These were the decisions in Indira Gandhi and Al-Manudu. Together, Semenanjaya, Indira Gandhi and Al-Manudu are known as the trilogy of cases. However, as is the case with most things that develop, they develop slowly and not without bumps along the way. And up to the point that the trilogy of cases were decided, there was still much lingering doubts regarding the applicability of the Basic Structure Doctrine in Malaysia. In particular, in many other constitutional challenges that surfaced after Al-Manudu, the government, in defending itself against constitutional challenges, continued to make attempts to revive Kuat Wah Kuan. In all challenges, arguments were repeatedly made to the extent that the Basic Structure Doctrine is inapplicable in Malaysia and that we are wrong to import a foreign doctrine into Malaysia from a completely different jurisdictional context. Let me be clear in that I think there is slight merit to that argument. For one, the primary basis upon which the Indian Basic Structure Doctrine was formulated is that the Indian Constitution has a preamble. That preamble highlights, among other things, India's status as a republic and a secular state. The Federal Constitution in Malaysia, on the other hand, does not have a preamble from which we can derive basic features. But as you can guess, that is not the end of the argument or the case for a similar doctrine in Malaysia. In later cases, the Federal Court was divided on the application of Basic Structure Doctrine in Malaysia. One such example was the case in Malaysian. Later, the Federal Court was again divided in cases such as Rovin Joti and Zaidi Kanapia. In both cases, the majorities rejected in one way or another the application of the Basic Structure Doctrine in Malaysia and seemed to have departed from clear and irrefutable precedents in the trilogy of cases. That was short-lived, as later, in the landmark decisions of Dinesh and Nevish, the Federal Court held that while the Basic Structure Doctrine is not applicable in Malaysia, a version of it called the Doctrine of Constitutional Supremacy remains law in Malaysia. Nevish is particularly relevant as, like Rovin Joti and Zaidi Kanapia, it concerned the interpretation of Section 4 of the Prevention of Crime Act 1959. In essence, Section 4 provided that so long as a magistrate in a remand hearing was presented with certificates signed by certain parties from the executive arm of government, then the magistrate was bound to order the detention of the detainee. These cases, including Malaysian, also concern in one way or another statutory provisions that restricted judicial review in the form of ouster clauses. Again, attempt was made by relying on Kuat Wah Kuan and related cases to contend that the judiciary was properly restricted by Parliament from reviewing the legality of the legislation and acts performed in accordance with the legislation. In both Dinesh and Nevish, the Federal Court unanimously upheld that the minority judgments in Malaysian and Zaidi Kanapia are correct and that those provisions were null and void. By these latest decisions, the position in our constitutional law stands, that is, that Parliament cannot enact laws that violate the basic features of the Federal Constitution and that the courts cannot be restricted from their inherent judicial powers of review against acts of Parliament or any executive acts or omissions because of Article 4, Clause 1 of the Federal Constitution. In this assessment, the courts can even strike down constitutional amendments that violate the basic feature of the Federal Constitution. In arriving at this conclusion, the Federal Court re-emphasized the position established in the trilogy of cases that the 1988 constitutional amendment did not remove judicial power, and that this only occurred because of the misinterpretation of the amended Article 121 Clause 1 in Kuat Wahkuan. While the doctrine of constitutional supremacy, which was held to be applicable in place of the Indian basic structure doctrine, was affirmatively recognized, the Federal Court did not have to resort to the basic structure doctrine of India to strike down the constitutional amendment to Article 121, Clause 1, having corrected the misinterpretation that arose in Kuat Wahkuan. In relation to constitutional supremacy, these cases rule that we need not resort to a foreign concept because the essence of the basic structure doctrine, unlike the Indian constitution, which had to imply it into the written constitution, in Malaysia, it is inbuilt. The problem, as I see it, was that all this while, the case was made both for and against the importation and adoption of the basic structure doctrine into our law. In fact, the struggle to have Kesavananda imported into Malaysia long predates Semenyih Jaya to cases that were decided in the late 1970s, such as in Loh Kui Chun and Pang Ching Hock. I need not delve into those cases as Semenyih Jaya and later Zaidi Kanapiah dealt with them. Suffice to state that the current cases now hold that the essence of the basic structure doctrine is applicable in Malaysia without having to rely on Indian authorities such as Kesavananda. Since India and Malaysia have similar written constitutions and legal histories, it is not surprising then that we should have a constitutional concept that is similar to theirs, though more properly grounded in our case on solid constitutional text and theory. Our methodology is simply this. Article 4, Clause 1 starts with the phrase, "This Constitution is the supreme law of the Federation." Then the Federal Constitution goes on to establish in its many provisions the Houses of Parliament and establishes its legislative powers in the list that I mentioned earlier. As such, Parliament was created by the Federal Constitution and its powers are circumscribed by it. Article 159 then caters for Parliament's specific powers to amend the Federal Constitution in accordance with prerequisite majorities and consents that Parliament must obtain. However, in wording that power, Article 159 Clause 1 uses these words: "The provisions of this Constitution may be amended by federal law." In Article 4 Clause 1, the Federal Constitution refers to itself as this Constitution, while in Article 159 Clause 1, it allows amendments to its provisions, and that too by federal law. Article 4 Clause 1 then goes on to say that any law passed after Merdeka Day that is inconsistent with the Federal Constitution is, to the extent of the inconsistency, void. This means that when Parliament passes a federal law to amend the provisions of the Constitution, which is narrower in meaning to this Constitution, then such a law is also capable of scrutiny and capable of being struck down by the courts. This is just a plain reading of these provisions for what they say. And when you read them in this way, they collectively mean that the Constitution is larger than the sum of its parts. And if we consider that it was a social contract that was concluded with the conditions to form Malaya and later Malaysia, there are parts of it that cannot be destroyed even by constitutional amendment if that amendment defaced the basic tenets of what Malaysia is today. You can then appreciate that this is not the Indian basic structure doctrine. It is our own doctrine of constitutional supremacy ingrained in Article 4 Clause 1. We have this express supremacy provision that should give us everything in line with the powers of judicial review established in Marbury and the essence of the basic structure doctrine which India had to read into its constitution. We are debating its existence when it is included into the very words of our federal constitution. This is therefore a measured balance. It does not mean that the Parliament cannot ever amend the federal constitution. For they have done so in many stellar cases, such as the recent constitutional amendment that equalized citizenship rights by allowing mothers of children born overseas with foreigner fathers to pass down their Malaysian citizenship to their children. Previously, the right to pass down citizenship to children born overseas was only conferred to Malaysian fathers who married non-Malaysian mothers. The existence of the doctrine of constitutional supremacy enshrined in Article 4, Clause 1 simply means that Parliament cannot unmake the Malaysian state by, for example, removing the judicial arm of government, removing Islam as the religion of the Federation, abolishing the monarchies, or other amendments that transform Malaysia to something other than what was intended by the social contract.